Welcome to the Supreme Court of the United Kingdom, where today we're hearing the appeal in the case of Meadows and Carr. The case is concerned with the assessment of damages for medical negligence. The appeal is being heard by a panel of 7 justices. Besides myself, there are also the Deputy President of the Court, Lord Hodge.
Good morning.
Lady Black. Lord Kitchen.
Good morning.
Lord Sales.
Good morning.
Lord Leggett.
Good morning.
And Lord Burrows.
Good morning.
The appellant is represented by Mr. Philip Havers, Queen's Counsel, and I'll now turn to Mr. Havers and invite him to begin his submission.
Thank you very much, my lord. As I think you all know, I represent the appellant together with my learned friend, Mr. Elliot Wolfe, and the respondent is represented by my learned friends, Mr. Simeon Maskery and Mr. Neil Davey. My lords and my lady, I propose to assume that you have had an opportunity to familiarise yourselves with the background to the appeal, and thus I propose to proceed at once to the argument. May I indicate at the outset what are our 2 overarching submissions? First, this claim falls squarely within the principles established by the Court of Appeal in the 2 cases of Parkinson and St James's NHS Trust and Groom against Selby, and accordingly the judge was right to find that the claimant was entitled to the costs associated with both her son's disabilities, that's to say, both his haemophilia and his autism. My lord, secondly, and my lord and my lady, secondly, we submit that SAMCO does not dictate some other outcome. On the contrary, on proper analysis, it confirms that outcome. So can I take you at once to the first of those 2 Court of Appeal decisions, the decision in Parkinson, which you will find in volume 2 at page 171. My lords and my lady, this was a wrongful conception case. The mother asked to be sterilised, but the sterilisation operation was carried out negligently and she became pregnant. She was warned by the consultant that the baby might be born with a disability, but she declined to terminate the pregnancy. And she did indeed go on to give birth to a child with severe disabilities. The Court of Appeal held that in principle, she was entitled to recover the additional costs of bringing up the child which were associated with those disabilities. The background to the claim was that the House of Lords had earlier decided that the ordinary costs of doing so were not recoverable, but had left open this question of whether, in the event that the child was born with a disability, that the additional costs associated with that disability were recoverable, and the Court of Appeal held that they were.
Mr. Havers, can I just interrupt just to mention a small point for you to bear in mind? Although the first page of this is just to do with page numbering,
yes,
although the page bears the number 171 in the bottom right-hand corner, it's actually page 172 in our electronic bundle for volume 2. So it may be that when you're referring us to authorities in that volume, you're going to have to add 1 to the numbers you were thinking of.
my lord, thank you for telling me that. That's another example of what were known as Lord Justice Sedley's laws of which will be...
They need updating now. But
they obviously do.
Yes, the principles remain the same.
Yes, well, I'll try and remember to add 1 to each. Can I just inquire? Well, we'll discover whether the same applies to volumes 1 and 2 1 and 3 when we get there, no doubt.
Yeah.
So, Lords, can I take you first to page 178? I hope it is. where at paragraph 12, Lord Justice Brooke began a historical survey of the relevant case law. At page 180 in paragraph 18, I draw to your attention that he expressly referred to the decision in Samco. In recent years, two other factors have emerged. The first is that it may be necessary on some occasions for a court to ask itself for what purpose a service was rendered, because that inquiry may stake out the limits of the duty of care owed by the person performing the service. And then he referred to the case by its name in the Court of Appeal, I think, rather than its name in the House of Lords. And so he was not only aware of Samco, but commented on it in that way. At page 188, I invite your lordships and my lady to note paragraph 50. I don't take you through it, but he set out his conclusions on the, or by reference to the barrage of, or the battery of tests which the House of Lords had taught the courts to use. And then can I ask you to go on to page 189, paragraphs 53 to 54. Where he said this: in this judgment, I am concerned only with the loss that arises when the child's significant disabilities flow foreseeably from his or her unwanted conception. There may well be foreseeable incidents during the mother's pregnancy and the time leading up to the birth of the child from which the child's disabilities have flowed, but these will not in the ordinary way be effective to break the chain of causation. If, on the other hand, there is evidence that a child's disabilities, discernible at birth, were caused by some new intervening cause, then the difficult and interesting issues that may arise in such a case will have to be resolved by applying well-known principles of causation to the facts of the case before the court. A negligent surgeon should not without more be held liable for the economic consequences of the birth of a child with significant disabilities if the child's disabilities were brought about between conception and birth by some ultraneous cause. Similarly, the ordinary rules relating to contributing negligence will be applied. Can I then ask you to turn to Lady Justice Hale's judgment beginning at page 194, paragraphs 74 and 75, where she said, of course, most pregnancies are not caused wrongfully, but this case proceeds on the basis that this one was. The whole object of the service offered to the claimant by the defendants was to prevent her becoming pregnant again. They had a duty to perform that service with reasonable care. They did not do so. She became pregnant as a result. On normal principles of tortious liability, once it was established that the pregnancy had been wrongfully caused, compensation would be payable for all those consequences, whether physical or financial, which are capable of sounding in damages. And I then go to 75. There is nothing unusual or contrary to legal principle involved. This is clearly reflected in the decision of the Inner House in Macfarlane's case. Scots law may express itself differently, but the principles are the same. What is needed is inuria and damnum. The inuria was the breach of duty of care. The damnum was the conception. Thereafter, the claim lay for the natural and probable, or in English law, the foreseeable consequences of the breach and the initial loss. And then if I could ask you to go on to page 199, paragraph 92. She said this: another question is when the disability must arise. Mr. Stuart Smith argued there was no rational cut-off point, as any manner of accidents and illnesses might foreseeably affect a child throughout his childhood. But that is part of the ordinary experience of childhood, in which such risks are always present, and the balance of advantage and disadvantage is deemed to be equal. The two serious contenders are conception and birth. The argument for conception is that this is when the major damage was caused, from which all else flows. This is what the defendants undertook to prevent. But there are at least two powerful arguments for birth. The first is that although conception is when the losses start, it is not when they end. The defendants also undertook to prevent pregnancy and childbirth. The normal principle is that all losses, past, present, or future, foreseeably flowing from the tort are recoverable. The second is that it's only when the child is born that the deemed benefits begin, and it is those deemed benefits which deny the claim in respect of the normal child. In practice also, while it may be comparatively straightforward to distinguish between ante and postnatal causes of disability, it will be harder to distinguish between ante and post-conception causes. Further, the additional risks to mother and child, for example, because of the mother's age or number of previous pregnancies, may be among the reasons for the sterilisation. I conclude that any disability arising from genetic causes or foreseeable events during pregnancy, such as rubella, spina bifida, or oxygen deprivation during pregnancy or childbirth, up until the child is born alive, and which are not novus actus interveniens, will suffice to found a claim. So, my lords, that was the decision and reasoning of the Court of Appeal in that wrongful conception claim. And I then turn to the other case of Groom and Selby, same bundle at page 35, which was a wrongful birth case. The brief facts were that the defendant had failed to detect that the claimant was pregnant when she consulted her at 7.5 weeks gestation with possible signs of pregnancy. That the defendant already knew that the claimant had wanted no more children and indeed had had a sterilisation, but had been pregnant at the time that the sterilisation operation took place. The upshot of the defendant's failure to detect that she was pregnant was that she was deprived of the opportunity to terminate the pregnancy, which the judge decided is what she would have done. The judge held that if told that she was pregnant, she would have done so. The child was born prematurely and went on to suffer from salmonella meningitis through exposure to a bacterium during the normal process of birth. And the claimant recovered damages for the additional costs of bringing up that disabled child. And as your lordships and milady will see, Parkinson was applied, and as you will also see, two of the members of that court, namely Lord Justice Brooke and Lady Justice Hale, had of course been members of the court which had relatively recently decided Parkinson. Can I take you first to page 39 and paragraph 17 in the judgment of Lord Justice Brooke. It will be seen from this description that the incidence of meningitis by this route is one of the natural, though fortunately rare, consequences of childbirth. Can I pick it up four or five lines further on? Since his clients, that's the defendant's breach of duty, caused the claimant's pregnancy to continue when it would otherwise have been terminated, and since Mr. Colin conceded that the chain of events that took place in this case was foreseeable, even if it was extremely rare, then if this was a straightforward personal injuries claim, the way would ordinarily be open for the claimant to recover damages for negligence. And then I go to 18. This is, however, a claim for economic loss, and then a reference to Parkinson. In Parkinson, two members of the present division of the court were concerned with what is called a wrongful conception claim, in which a child would not have been conceived but for the negligence complained of, as opposed to the present wrongful birth claim, in which a pregnancy would not have been continued but for the negligence complained of. And then he refers to something that he said in Parkinson, and then at 19 explains what he had in mind when he said it. Can I pick it up at 20? In the present case, however, there is no reason to suppose that any abnormality would have been detected in the fetus if the claimant's pregnancy had been detected, as it should have been, on November the 21st or shortly thereafter. In our judgments in Parkinson, Lady Justice Hale and I made some observations about the principles to be applied in wrongful conception cases, and these appear to me to be equally applicable to a wrongful birth case of the present type. He then sets out some of their judgments in Parkinson, and I pick it up in paragraph 23 at page 41, about 5 lines in. We are concerned in the present case with a child whose severe handicap arose from the normal incidence of conception, intrauterine development and birth. Her prematurity, which made her particularly vulnerable, was not due to any new intervening event, and her exposure to the bacterium, which proved her downfall, occurred during the process of birth. All the causes of a meningitis were in place when the umbilical cord was severed. All that remained was for the bacterium to penetrate a weak point in the child's skin or mucous membranes, and the damage was done. On this basis, it appears to me that this court's earlier decision in Parkinson is dispositive of this appeal. If we go to the battery of tests to which I referred in paragraph 50 of my judgment in that case, the route to the judge's conclusion in this case would be on the following line. 1. In the absence of evidence of any new intervening act, the birth of a premature child who suffered salmonella meningitis through exposure to a bacterium during the normal process of birth was a foreseeable consequence of Dr. Selby's failure to advise the claimant that although she had been sterilized, she was in fact pregnant. 2. There are no difficulties about proximity. 3. There is, as in Parkinson, no difficulty in principle in accepting the proposition that Dr. Selby should be deemed to have assumed responsibility for the foreseeable and disastrous consequences of performing her services negligently. 4. Dr. Selby knew that the claimant had been sterilized and wanted no more children, let alone children with serious handicaps. And Dr. Selby's duty of care, when advising on the symptoms of which the claimant made complaint, must be deemed to include the purpose of ensuring that if the claimant was indeed pregnant again, she should be informed of this fact, so as to enable her to take appropriate steps to prevent the birth of another child if she wished. And I invite your lordships and my lady to take particular note of that sub-paragraph, since I shall be returning to it in the course of my submissions. 5. As in Parkinson, no radical step into the unknown is in question here. 6. As in Parkinson, an award of compensation which is limited to the special upbringing associated with rearing a child with a serious disability would be fair, just, and reasonable. Lords and my lady, can I then turn to the judgment of Lady Justice Hale at the foot of the same page? I agree, the principles applicable in wrongful birth cases cannot sensibly be distinguished from the principles applicable in wrongful conception cases. So she saw no difference in terms of the principles which apply to each type of case. Over the page, paragraph 29, she continued, in such cases, unlike the usual run of wrongful birth cases, there is no direct connection between the negligence and the disability. In cases such as Rand and then the other cases she refers to, there has been a negligent failure to diagnose the disorder which leads to or to screen properly for the disability in question. Here, the negligence consists in allowing the pregnancy to continue when the claimant did not wish to be pregnant at all. Nevertheless, in Parkinson, this court took the view that the principle in McFarlane could properly be confined to the ordinary costs of bringing up a healthy child in a wrongful conception case. The extra costs of bringing up a disabled child could be claimed even though there was no direct link between the negligence and the disability. Left to myself, as I made clear in Parkinson, I would not regard the costs of bringing up a child who has been born as a result of another's negligence as pure economic loss. Rather, they are economic losses consequent upon the invasion of bodily integrity suffered by a woman who becomes or remains pregnant against her will. That is an additional reason for confining the principle in McFarlane to the actual decision in that case. That is, to the cost of bringing up a healthy child. Whether one regards this as a scope of duty question or a scope of damages question matters little. As I also made clear in Parkinson, insofar as we are required to apply the battery of tests laid down by the House of Lords in determining the ambit of liability in any novel type of case, I agreed with the careful analysis and application of those tests by Lord Justice Brooke in that case. It is fair, just and reasonable that a doctor who has undertaken the task of protecting a patient from unwanted pregnancy should bear the additional costs if that pregnancy results in a disabled child. It follows that I also agree with his analysis in this case. And then paragraph 32, there will always be borderline cases in the application of any principle. In Parkinson, Lord Justice Brooke and I were also agreed on the source of the disability. It must be genetic or arise from the processes of intrauterine development and birth. That was what the doctor negligently failed to prevent. M's meningitis was bad luck in the sense that many newborn babies do not succumb to such infections, but it arose from the process of her birth, during which she was exposed to the bacterium in question. As I've said, Samco wasn't expressly referred to in the course of the judgment, nor indeed cited to the court, it seems, but two of the members of that court had been members of the court in Parkinson, where it was. Lords, we submit that it's very important to note that this case of Groom and Selby was a wrongful birth claim. True it is that, and the respondent relies on this, as the doctor knew, the claimant had decided that she didn't want any more children, and that was the reason, or certainly one of the reasons, why the doctor should have carried out a pregnancy test when the claimant consulted her at 7.5 weeks gestation with possible signs of pregnancy. But the claim was a wrongful birth claim because what the claimant was deprived of was the opportunity to terminate her pregnancy, which the judge found she would have done if the pregnancy test had been carried out and she had discovered that she was pregnant. And I refer back to that paragraph in Lord Justice Brooks' judgment that I showed you a few moments ago. It matters not, we submit, for the purposes of analysis, that she didn't want any more children, whereas in the present case, the claimant didn't want a child with haemophilia. The purpose of the doctor's duty, the purpose of the exercise undertaken by her in both cases, was to carry out whatever investigations were necessary so as to provide the mother with the necessary information to give her the opportunity to terminate her pregnancy. In Groom and Selby, the information being that she was pregnant. In the present case, the information being that she was a carrier of the haemophilia gene. And of course, in each case, the judge found, or rather in the present case, the respondent admitted, that if provided with that information and thus given the opportunity to terminate the pregnancy, that is what the mother would have done. In any event, we submit that in principle, there should be no distinction between cases where the mother didn't want any pregnancy, that's the wrongful conception cases, and cases where the mother didn't want this particular pregnancy, the wrongful birth cases. In each case, the mother was left with a pregnancy she did not want. It should not matter that in one case, she didn't want that pregnancy because she did not want any more pregnancies, whereas in the other case, she did not want this particular pregnancy. We submit that the key point is that in neither case did the mother want the pregnancy in question. To distinguish between the two involves distinguishing between the reasons why the mother did not want the pregnancy in question. As the judge, we submit, correctly held. See paragraph 58, and I'll just give your lordships and my lady the reference. It's volume 3, page 82, or volume 1, page 121. Your lordships and my lady will have seen that some of the documents in volume 1, the key documents, have been pulled together in volume 3. And of course, in each case, the consequences are the same. The unwanted pregnancy is allowed to continue to birth with all the consequences that that entails in terms of disabilities of the child arising from the normal incidence of pregnancy, of conception, pregnancy, and birth. Mrs. Justice Yip said that such a distinction seems unattractive, arbitrary, and unfair, and we respectfully agree. Yes, my lord.
The point is not so much, is it the mother's reasons, but what the doctor's asked to do.
We respectfully agree.
In Parkinson and Groom, the doctor is asked on the one hand to take care to prevent any pregnancy occurring, and on the other hand to prevent any birth occurring. And so when they fail in that duty, they're liable for the consequences of that, subject to remoteness. But in our case, the doctor's not asked to take care to prevent any pregnancy or any birth, but only to provide information about haemophilia. So that is the extent, isn't it, of the responsibility that the doctor's undertaking.
Well, that is indeed the respondent's case and the decision of the Court of Appeal. Lord, in the Groom and Selby case, it is critical, we submit, to understand that it was a wrongful birth case, that the doctor's wrongful conduct was in failing to test the claimant to see if she was pregnant when she attended at 7.5 weeks. That was the wrongful conduct in question. And that's what made that case a wrongful birth case rather than a wrongful conception case. And the consequence of I'm so sorry, and the purpose of the doctor's duty in that case, namely to test the mother to see if she was pregnant, was in order to give her the opportunity to terminate her pregnancy, having discovered that she was, contrary to what she had intended, pregnant after all. So the key about Groom and Selby is that, as in the present case, the wrongful conduct of the doctor was to deprive the mother of the opportunity of terminating her pregnancy.
Yes, but in that case, it was to prevent any birth of any child, whereas in our case, it was focused on preventing the birth of a haemophiliac child only.
Lord, with respect, no, because that would be then to look at the reasons why the mother in each of the two cases didn't want that particular pregnancy to continue. In Groom and Selby, the fact that the mother hadn't wanted any more children was simply part of the background picture. It was what would have made the mother want to terminate that pregnancy. So we would submit that the focus in Groom and Selby, as in the present case, is and has to be on the termination or the opportunity to terminate the pregnancy. In other words, the position as it arose when, in the case of Groom and Selby, the mother should have been given that opportunity as a result of being tested for pregnancy, and in the present case, when the mother should have been told that she was a carrier of the haemophilia gene, which would have given her the same opportunity in a future pregnancy to terminate that pregnancy if, on testing, her baby was found to have haemophilia. Well, that's why I began my submissions on Groom and Selby by stressing how important it is to note that it is a wrongful birth claim. Lord, another similarity between wrongful conception and wrongful birth cases is that the disability in question isn't caused directly by the doctor's negligence, but is caused indirectly because it arises from the normal incidence of conception, pregnancy, and birth, and was not caused by some new supervening event, and that's accepted in the present case. So we submit that the Court of Appeal was correct to hold in Groom and Selby that the principles in wrongful conception and wrongful birth cases are the same. As Lady Justice Hale said, they cannot sensibly be distinguished. And this is of some importance in the present case because the respondent has always accepted that if this is a wrongful conception claim, then the claimant is entitled to recover for both a child's haemophilia and his autism. As in Groom and Selby, the disability in question was, in this case, was just bad luck, that's to say the autism. In Groom and Selby, it was the child's meningitis. As I say, in the present case, it was his autism. It is true that the defendant did not assume any particular responsibility in relation to autism, but neither did the defendant in Groom and Selby assume any particular responsibility in relation to the child's meningitis. But what the defendant did assume was responsibility for providing the claimant with the opportunity of terminating any future pregnancy if, I say, it turned out that the child was, or rather had, haemophilia. So we submit as follows by reference to the principles in Parkinson and Groom and Selby. First, the principles in those cases apply to the present claim, as the judge, we submit, correctly held. As in Groom and Selby, the purpose of the defendant's duty in the present case was to carry out whatever investigations were required to enable her to tell the claimant whether she was a carrier of the haemophilia gene, so as to provide her with an opportunity to terminate any future pregnancy if it turned out that her baby had haemophilia. And it's interesting to note that the Court of Appeal has agreed that that was the purpose of the duty in this case. Can I take the court, please, to the judgment of Lady Justice Nicola Davis, who gave the only substantive judgment in the case. I've used volume 3 for these purposes, and the page number, I hope, in volume 3 is page 64. But if any of your lordships or my lady is using volume 1, the reference is page 32. But if you go to page 64 in volume 3, which I hope begins with paragraph 27 of her judgment in the Court of Appeal, with which both the other members of the court agree, you should find under 27.1, she says, accordingly, I find that, 1, the purpose of the consultation was to put the respondent in a position to enable her to make an informed decision in respect of any child which she conceived who was subsequently discovered to be carrying the haemophilia gene. And that, we submit, is correct. That was the purpose of the duty in this case. And the reason why was, as I've said probably too many times already, to give the claimant the opportunity to terminate that pregnancy. Thirdly, we submit the defendant's breach of duty deprived the claimant of that opportunity because testing would have shown that her baby had haemophilia. Fourth, as the defendant has agreed, if given that opportunity, the claimant would have terminated the pregnancy. Fifth, her child's autism is and was, as has been accepted, a normal incident of conception, pregnancy, and birth. Sixth, the defendant has made two important concessions, first as to but-for causation, and secondly as to reasonable foreseeability. Can I take you to them? They're set out in the Statement of Facts and Grounds, which you will find at page 4 of volume 3, or at page 38 of volume 1. And under paragraph 4, summary of issues, you will see 4.1, the parties are agreed that little a, but for the respondent's negligence, adage 1 would not have been born because the appellant would have been offered and would have agreed to undergo a termination of her pregnancy. So that's but for causation. And then C, it was reasonably foreseeable that as a consequence of the respondent's breach of duty, the appellant could give birth to a child that suffered from a condition such as autism as well as haemophilia. And thus, we submit that for those reasons, the claimant is entitled to recover the additional costs associated with both conditions. Now, Lord and Lady, those are our submissions on, well, that is our first overarching submission. This case falls fairly and squarely within the principles of Parkinson and Groom and Selby. So I turn to the second overarching question. Does SAMCO dictate a different outcome? Now, as we say in paragraph 19 of our written case, I don't turn it up, but the reference is volume 3, page 16, or volume 1, page 50. Determining the scope of the duty is but one of a variety of filters which the court applies to assign responsibility for the consequences of a breach of duty. However, it is rarely invoked in personal injury or clinical negligence cases because the courts have always taken a broad approach to categorizing kind of damage in such cases. And your lordships will recall, or Justice Brooks' comment on SAMCO in Parkinson, it's only in some cases that it's necessary to apply SAMCO. By contrast, defining the scope of the duty has become a key factor in commercial claims of pure economic loss. Secondly, each case self-evidently must be taken as it comes on its own facts. As we say in paragraph 25 of our written case, the facts in SAMCO and in Hughes Holland were far removed from the facts in the present case. Those cases concern losses suffered by commercially astute clients who had entered into commercial transactions in reliance on negligent advice or information provided by valuers or solicitors, whereas here your lordships are concerned with information provided by a doctor to her patient and the subsequent wrongful birth of the patient's child. But we submit application of the SAMCO filters or principles, or as I understand it's being called, toolbox, leads to the same outcome. That's to say, the outcome for which we contend. First, I address the issue of the kind of loss, the question of the kind of loss, which was how Lord Hoffman's analysis began. In other words, for what kind of loss is the claimant entitled to compensation? Now, I know that your lordships and my lady have looked at SAMCO in much detail, I think at a hearing something like 2 weeks ago. So unless you would be assisted by me taking you back to Lord Hoffman's judgment at every turn, I was going simply to give you the references for present purposes. The reference to the lengthy passage in his judgment where he addressed the question of kind of loss is to be found in volume 2, 265. Now, we submit that question, the kind of loss question, has already been answered by the Court of Appeal in Parkinson and Groom, namely, the kind of loss in wrongful conception and wrongful birth cases extends to cover the additional costs associated with the child's disabilities, where those disabilities arise from the normal incidence of conception, pregnancy, and birth. And as we shall see, we submit a kind of loss which was within the scope of the relevant duty, to which question I turn next. So, scope of duty. Lord Hoffman said that determining the scope of the duty involves an examination of the purpose for which the duty was imposed. In the present case, as your lordships and my lady have already seen, the purpose of the duty, as the Court of Appeal held, was to provide the claimant with sufficient information to give her the opportunity to terminate any future pregnancy if that pregnancy was afflicted by haemophilia. So, if I may put it this way, so far so good in terms of the SAMCO analysis and its application to the present case. That takes me on to information cases on the one hand and advice cases on the other, Category 1 and Category 2 cases. Now, it seems that the Court of Appeal treated the present case as a Category 1 information-only case. That's to say, a case where the purpose of the duty was to provide information for the purpose of enabling someone else to decide on a course of action. And in those cases, Lord Hoffman held that if the person under the duty is negligent in failing to ensure that the information is correct, he or she will be responsible for all the foreseeable consequences of the information being wrong. Can I now take the court to that passage in SAMCO, Volume 2, page 268, letter F. And the passage in question begins at E, where he makes the distinction between information on the one hand, advice on the other. And at F, he says, if his duty is only to supply information, he must take reasonable care to ensure that the information is correct. And if he is negligent, he will be responsible for all the foreseeable consequences of the information being wrong. Now, I've submitted already what we say was the purpose of the duty in the present case, and the defendant, as you've seen, has admitted that it was reasonably foreseeable that as a consequence of her breach of duty, the claimant could give birth to a child that suffered from both haemophilia and autism, in which case, on the face of it, if this is an information-only case, the defendant is liable for both those conditions. But in fact, we say that this case is more like a Category 2 advice case for these reasons. First, it wasn't just a case where the defendant provided wrong information. She also failed to arrange for the correct investigations, specifically to refer the claimant to the hematologist for genetic testing, as the defendant has admitted. Secondly, the claimant was entirely dependent on the defendant for taking whatever steps were necessary to discover whether she was a carrier of the gene. And thirdly, a decision to terminate any future pregnancy would have been based solely on whether the claimant was a carrier of the gene, because we know that if she was, and if it turned out that her baby had haemophilia, she would terminate the pregnancy.
Lord Leggett wishes to ask a question.
Yes, my lord.
Havers, you can't say, can you, that the doctor was advising whether the patient, whether the claimant should terminate future pregnancy or not, and taking account of all the considerations that she might wish to apply to that.
No,
It was only on any view advising on one particular reason, or one particular reason why she might choose to terminate a pregnancy.
Lord, she was, but she was advising on the only reason that the claimant would wish to terminate a future pregnancy, as she knew or must have known, because that was why the claimant had consulted her in the first place. She wanted to know whether she was a carrier of the haemophilia gene, because if she was, she wanted to terminate any future pregnancy if it turned out that her baby had haemophilia. That was the whole purpose of the exercise. So it must have been obvious to the doctor that there was only ever going to be one consideration, one factor in play in the event of a future decision whether to terminate the pregnancy or not, and that
I don't see why that should be at all obvious. She might, when she got pregnant, have decided for other reasons that she didn't want to go through with that pregnancy if she'd broken up with the father or had felt, or for all sorts of other reasons which are totally unconnected with the doctor's responsibility. All the doctor knew was that she wanted on any account to prevent giving birth to a haemophiliac child, not whether she wanted to get pregnant or when she did, or why she might terminate for other reasons any future pregnancy.
Well, no, there are no other reasons that it could, in our submission, sensibly be suggested would have been in play. I mean,
I mean, that may be so on the facts, but the pregnancy was several years later anyway.
It was, but that was the very reason why the claimant consulted the doctor in advance, as early as she did, because she wanted to ensure that if she became pregnant, she would know whether she would have to test the baby for haemophilia, so that if the test was positive, she'd be able to terminate the pregnancy. And as I say, that was the only reason why she consulted the doctor in the first place. So we do submit that a decision to terminate a future pregnancy would have been based solely on whether she was a carrier of the gene. Can I take you to what the judge found on this? Because it's very relevant to the question my Lord or Legate has just put to me. If I could ask you to go to her judgment, paragraph 7, which you will find either in volume 3 at page 71 or in volume 1 at page 114. Paragraph 7. Core facts, it's headed, and it begins, at the outset of the trial, I provided a summary of the facts as I understood them to be. Having read the papers, counsel helpfully reviewed my summary and suggested some minor amendments and additions so that the following can be seen as an accurate summary of the core facts. Can I ask you to go to little Roman 9? Had the claimant been referred for genetic testing in 2006, she would have known. That was the doctor's, the respondent's failure. She would have known she was a carrier before she became pregnant. In those circumstances, she would have undergone fetal testing for haemophilia. Such testing would have revealed that the fetus was affected. In such circumstances, the claimant would have chosen to terminate her pregnancy and Adejuwan would not have been born. So on the facts as agreed by the parties, there was no question of a possibility of some other consideration coming into play. The parties agreed, and the judge found as a fact that if the baby had been found to have haemophilia, the claimant would have terminated the pregnancy.
Lord Burrows has a question.
Yes, my lord.
Yes, Mr. Havers, I don't know whether you'll be coming back to this, but you've moved on, I think, from whether this case was one of information or one of advice. I'd just like to take you back to the question of applying SAMCO if this is a case of information rather than advice.
Yes.
Because I'm not sure what your submission is on that. My understanding would be, but correct me if I'm wrong, that if it's an information case, we have to ask ourselves the counterfactual question. If this information had been correct, would the loss have been suffered, the same loss had been suffered in any event? And on the face of it, the answer to that question is, had the information been correct, that is, that she was a haemophilia, that she was not a haemophilia carrier, she would in any event have given birth to an autistic child.
My lord, I am coming to that. The short answer is that this was you simply cannot say that, because this pregnancy was indivisible. You can't divide up the component parts of this pregnancy, and therefore you cannot say that if she had not been a carrier of the haemophilia gene, and therefore if her child had not had haemophilia, which she wouldn't have done in that counterfactual situation, you can't say that that baby would have been born not without haemophilia, but with autism. Lord, if I may, I'm going to develop that a little bit more, but that's my short answer to your Lordship's question.
Thank you.
So, my Lord, if it is an advice which we submit, it is more like, and I'm going to suggest in a moment that part of the difficulty here is that the distinction between category 1 and category 2 cases isn't very well suited to determining a case such as the present. But if it is an advice case, then on those findings of fact, the claimant is entitled to recover her losses in respect of both the haemophilia and the autism. But as I just said, and as we say in paragraph 27 of our written case, it may be that this distinction isn't well suited to determining the purpose for which the duty was imposed in a wrongful birth claim, and it may be more appropriate and more useful to look at the formulation suggested by Lord Sumption in Hughes Holland at volume 2, page 66. And let me just read it to you first before I take you to it. That's to say, whether the loss flowed from the feature of the defendant's conduct which made it wrongful. He was picking up something that Lord Hoffman had said in Samco. I'll just give you the reference, volume 2, page 267, C to D. But when I take you to Lord Sumption's articulation of the point in volume 2, page 67, sorry, I'm looking at page 67, whereas my bundle, of course, is numbered 66. I'm so sorry. Towards the foot of the page, this is paragraph 38. Just above letter H, the question which it poses is rather whether the loss flowed from the right thing, i.e. from the particular feature of the defendant's conduct which made it wrongful. That turns on an analysis of what did make it wrongful. So if we approach Samco from that standpoint, we submit that it's clear that what made the defendant's conduct in the present case wrongful were two things. Firstly, her failure to refer the claimant to the haematologist for genetic testing. And secondly, her advice to the claimant that she was not a carrier of the gene. And the loss which flowed from that was the loss of the opportunity for the claimant to terminate her pregnancy in all its component parts, which we know she would have done if she'd been told that she was a carrier of the gene, which in turn led to the birth of a child with both haemophilia and autism. So on that analysis, the claimant should recover for both. Nor is this case, the present case, one where the recipient of the information was in a position to balance other risks, because she wouldn't know, and no one could have told her, whether her child would develop autism. That was one of many silent conditions which would not have been detectable. So, as we say in paragraph 27 of our written case, hers was a binary choice: continue with the pregnancy or terminate. And that decision depended entirely on whether she was a carrier of the gene, as I've sought to submit already. There was therefore nothing else to weigh in the balance. Now, my lord, turning to the counterfactual issue, we submit that the judge was also right to find that on the facts of this case, it is incorrect to try to determine the scope of the duty by reference to the counterfactual question. In other words, to what would have occurred if the information had been correct. And we say she was right for the reasons she gave, which she set out in paragraph 56 of her judgment at page 821 of volume. Sorry, that can't be right. Page 82 of her of volume 3, or page 121 of volume 1. And can I invite you to go to that paragraph 56? Where she says, I agree with Mr. Havers when he says that it is inapt to ask, as the defendant does, what losses would have occurred if the information had been correct. The pregnancy is indivisible. It cannot be said that, if the advice had been accurate, the claimant would have had a child with autism, but not with haemophilia. Unlike the mountain and the avalanche, which existed quite independently of the condition of the man, product of a particular pregnancy, which only continued to exist as a result of the negligent advice. And that is also, as she was hinting, at the answer to Lord Hoffman's parable of the mountaineer's knee. It is impossible, we submit, to say that if the claimant hadn't been a carrier of the haemophilia gene, her child would have been born without haemophilia, but with autism. The pregnancy is indivisible. You can't divide it up into separate component parts. So whereas the mountaineer's injury had nothing to do with his knee, as autism had everything to do with this pregnancy. It was a component part of it, and the pregnancy was only continued because of the respondent's negligence. So, my lords and my lady, we submit...
Lord Porritt has a question for you.
Yes, my lord.
Yes, I must say that reading that paragraph at the moment, I do have a degree of difficulty understanding it, because as I understand it, there is no question of any causal link between haemophilia and autism.
No.
So when, I frankly don't at the moment understand the statement by Mrs. Justice Yip. It cannot be said that if the advice had been accurate, the claimant would have had a child with autism but not with haemophilia. That just seems to me an irrational assertion.
Lord, on the contrary, what she's saying is that a pregnancy is indivisible. It's the product of a particular conception. And this pregnancy, which was a product of a particular conception, was a pregnancy which involved a child with both haemophilia and autism. But if the mother had never been a carrier of the gene, and if the child therefore hadn't had a haemophilia, this would have been a different pregnancy. It wouldn't be the same pregnancy without the haemophilia, but with the autism. It would have been a pregnancy arising from a different conception and the mixture of different genes and a different outcome.
The counterfactual is a thought experiment. Obviously, it's something that didn't actually happen. Is it an answer to say that the counterfactual is unrealistic in the sense that it plainly isn't something that happened?
Well, it's not plainly something that didn't happen. It's something that couldn't have happened. And well, the counterfactual is simply, we suggest, another device for, as it were, testing the, or trying to ascertain the extent of the liability of the defendant. But it doesn't work, I think, is what I'm submitting to the court. It doesn't work in this case for the reasons I've sought to suggest. And if it doesn't work, then it doesn't assist your lordships and my lady in coming to a determination of the appeal.
All we're doing is imagining a situation where the claimant is not a carrier of the haemophilia gene, but otherwise becomes pregnant as she did.
Well, Lord, this, can I say two things in response? That this case is concerned with a particular pregnancy, which you can't replicate a particular pregnancy. Every subsequent pregnancy will, by definition, be different. So the analogy doesn't work because, or the counterfactual test doesn't work because you can't say, as in the parable of the mountaineer's knee, that he would still have been injured by the avalanche. I'm never quite clear where the avalanche came from, but anyway, it seems to be accepted that that was what caused the injury. You can't say that, whereas in the mountaineer parable, he would have been injured anyway because the avalanche had nothing to do with his knee. In the present case, you can't say that this child would have had autism anyway, because his autism was part and parcel of this particular pregnancy, which also included his haemophilia.
I see.
Yes, my lord.
I mean, doesn't it prove too much, that argument? It could always be applied, for example, in the valuer's cases. Wouldn't you say, well, of course, it's an indivisible loss that the lender has suffered. It's just a hypothetical to ask what would have happened if the evaluation had been correct. As it is, the entire loss was suffered in this particular set of circumstances, with the fall in the market and so forth. So really, we should forget about the counterfactual.
Lord, we would submit no, because the various components of the loss in the valuer's cases were truly divisible. You could separate one from the other, but you can't do that in a wrongful birth case, where the pregnancy in question is indivisible, and therefore you can't separate out the autism on the one hand from the haemophilia on the other hand. They're all part and parcel of the same pregnancy. That's my answer.
Yep.
Lord Hodge.
Mr. Havers, does your case depend on there being a particular pregnancy, or rather is it that, given that the purpose of the duty is to provide the appellant with necessary knowledge to make an informed decision in relation to the continuation of any future pregnancy affected by the haemophiliac gene, then it is really any pregnancy in which haemophilia is detected is the pregnancy that you're dealing with, not this particular pregnancy of this particular child.
Well, my lord, with respect, no, because what the case is concerned with is first the losses sustained by the claimant as a result of the her child being born with haemophilia, and the losses involved are agreed in terms of the quantum, and so the only question is therefore whether the additional losses associated with the child's autism are also recoverable, and that demonstrates, we submit, that the court is concerned with this particular pregnancy.
Yes. Thank you.
So, my lords and my lady, we submit that Samco does not dictate the outcome contended for by the respondent. On the contrary, it confirms the outcome already arrived at, applying the principles in Parkinson and Groom and Selby. However, if your lordships were to conclude that Samco does dictate some other outcome, can I take you to paragraph 41 of our written case, which you'll find in volume 3, page 27. Insofar as the court concludes that proper application of the existing case law on scope of the duty results in an outcome that leaves this parent rather than the tortfeasor as bearing the burden of the negligence, then the test should be broadened to bring cases of wrongful birth in line with those cases where the clinician's wrongdoing causes direct physical injury. Lord, what we submit on this point is that your lordships, insofar as you conclude that Samco would dictate some other outcome, that your lordships should make an exception to the application of Samco in cases of clinical negligence, in particular arising out of wrongful birth. And we make 6 short points in support of that invitation to the court. First, in conventional cases of negligent conduct which causes physical injury, it has not been found necessary to place limits on the scope of the duty of care or the extent of the defendant's liability for the foreseeable consequences of his acts. Secondly, by contrast, in cases where damages for economic loss, which are the result of negligent misstatement, additional limits have been applied to limit the potential for what has been described as foreseeable but indeterminate and possibly ruinous loss by a large and indeterminate class of plaintiffs. And thus it was felt that foreseeability of reliance alone was not a sufficient limiting factor. 3, cases of pure economic loss, which have the potential to invoke the Samco cap in a clinical negligence context, are very rare. You'll recall that Lord Brooke did not consider it necessary to do so in either Parkinson or Groom and Selby. However, the consequences of a defendant's failings are no different than a case in which a defendant has directly caused the harm. And this case is a good illustration of that. Fourth, further, unlike cases in a commercial context where the losses may be indeterminate or ruinous, the measure of damages arising in cases for clinical negligence claims, such as this, is assessed within well-prescribed limits under ordinary cautious principles, often the largest head of loss being the cost of care. So they do not invoke open-ended claims, for example, for loss of profits. Fifth, it is already accepted that had this been a case of wrongful conception, the claim would have succeeded in full. And for the reasons I've already outlined in my submissions, a rule which distinguishes the right to recovery on the basis of the reason why a claimant should want to avoid or terminate a pregnancy, we submit should be irrelevant. And then finally, a principle based on a fictional counterfactual, which results in this claimant recovering from the tort fees at only 15.5% of the agreed total cost of upbringing her disabled child. That cannot, we say, be said to be fair, just and reasonable when those losses arise from a single individual pregnancy. Lords and my lady, finally this, I wasn't proposing to take you to the judgment of Nicola Davis, Lady Justice Nicola Davis in the Court of Appeal, or to make detailed comments on it. I can do so if that would assist your lordships and my lady, but I rather doubt that it would. And unless it would, my lords and my lady, those are our submissions, which I hope I've timed reasonably well to fit in with your mid-morning break.
Yes, Lord Burrows has a question.
Yes, my lord.
Could I ask you about the hypothetical that I think your opponent has put forward? But just in case it gets lost, let's assume that this particular claimant actually went ahead but gave birth to an autistic child without haemophilia.
Yes.
Would you regard the position as being the same?
My lord, I was asked that question by the judge, as she records in paragraph 69 of her judgment. I answered, I suppose, as a result of over-enthusiastic caution, yes. She rightly rejected that answer in paragraph 69 and said that that was that the answer was incorrect. Can I take you to paragraph 69? It's volume 3, page 84. And if you pick it up halfway through paragraph 69, you will see that she said, I do, while that result would follow as a matter of simple but-for causation, I do not think that many people would consider the recovery of damages to be just in those circumstances. However, with respect, I do not think Mr. Havers was right about this. The birth of a disabled child who did not have haemophilia would have had nothing to do with the defendant's negligence. Such a case could truly be said to be analogous to the Mountaineers League and Samco. The crucial factor that the disabled child resulted from a pregnancy afflicted by the very condition about which the doctor was consulted would have been missing. In reality, I doubt very much that the claimant would have even contemplated bringing proceedings in those circumstances. So, my lord, the answer to your lordship's question is no, I don't so submit, but I do rely upon what she says in paragraph 69.
With respect, when it said the birth of a disabled child who did not have haemophilia would have had nothing to do with the defendant's negligence, on your submissions, that couldn't be correct, could it? She wouldn't have gone ahead with the pregnancy.
Well, I'm not sure whether the example your lordship was putting to me was the same as the example that the judge put to me. But your lordship's question to me was, well, what would be the position? What would be my position if the baby was born only with autism and not haemophilia?
Yeah.
And that so perhaps I ought to restrict myself to answering your lordship's question rather than referring to the judge. My lord, that presupposes that the mother had tested the baby and found that the baby did not have haemophilia.
No, what I'm assuming is exactly the same as occurred in terms of advice and non-testing, that it happened to be the case that the child was born without haemophilia, but with autism.
With respect, I can't see how that could medically have happened.
I see. Okay.
The testing would have shown that the child had haemophilia, and therefore the child was bound to be born with haemophilia.
Right. I'm putting a hypothetical situation. You may say it's too unrealistic, but thank you.
Well, what I'm saying is it could never have happened for those reasons.
Well, if there are no further questions at the moment, then thank you, Mr. Havers, for commendably succinct and clear submissions. We'll adjourn now for 5 minutes and resume at 10 to 12.
Thank you, my lord.
I think we're now ready to resume, and we have to hear now from Mr. Simeon Maskery, Queen's Counsel, on behalf of the respondent to the appeal.
Thank you, my lord, my lady. I appear, as you know, with Mr. Neil Davey, and like Mr. Havers, I will not go through the background to the case. My lords, my lady, we submit first that Groom and Parkinson were correctly decided. We submit second that Groom and Parkinson were not dealing with the issue with which my lords and my lady are having to deal with, namely, what is the scope of the liability or the consequences that a defendant should be responsible for. Third, we submit that in Parkinson and Groom, the Court of Appeal were well aware of Samco, as Mr. Havers has pointed out, and did not in any sense suggest that Samco should not be applied in a clinical negligence case or a clinical negligence case, and in particular a wrongful birth or wrongful conception case. They did not suggest that there should be any amendment to the Samco principle, principally, of course, because they were not dealing with it. And in those circumstances, our submission is that one simply looks to see, one, how Samco is applied, and two, then applies it, bearing in mind always that the purpose of Samco is that there should be an allocation of risk. Having given that introduction, may I start at the beginning and apologize in advance that some of the concepts that I'm going to address now, very shortly, are not controversial and indeed could be regarded as trite. But nonetheless, it puts in context some of my later submissions. In any negligence case, the court is required to go through a number of stages. First, is there a duty owed to the claimant? Second, what is the scope of that duty and the scope of the liability? In other words, for what consequences of an act or omission will a defendant be liable? Third, was that duty breached? Fourth, what is the loss that has been sustained as a consequence of the breach? And finally, fifth, are there any causation filters, foreseeability, remoteness, mitigation of loss, etc., that limit recoverability? Now, true it is that in personal injury actions, one rarely articulates each stage of the process. But that doesn't mean that each stage of the process isn't significant or important. It simply means that in any given case, it's unnecessary to articulate the process that what has gone through. And so it becomes clear, we submit, that given that the second stage, what is the scope of the duty and the scope of the liability, is being dealt with, comes before one deals with the causational filters. That is because one does not look at but-for causation before determining the scope of the duty. But-for causation is simply a shorthand for saying but for the wrongdoing, what loss has flowed. And you can't determine that until you know what the wrongdoing is, and you can't determine the wrongdoing until you know the scope of the duty and the scope of the liability. None of that, I suspect, is particularly controversial. So we turn to number 2, the scope of the duty and the scope of the liability. Mr. Havis's submissions, in our respectful submission, really dealt hardly at all with allocating responsibility for risks between the parties. But that is precisely what that second stage is about. It's about determining which risks a defendant is going to be responsible for and which risks a claimant is going to be responsible for. And that, we submit, has been the law, certainly for the last 60 years or so. May I take you to the authorities bundle 2, and take you to the Hughes-Holland case. And may I invite you to look at, I think it will be page 59, I'm sorry. Paragraph 20. I think it's actually page 60, paragraph 20. Letter H. And we see there that Lord Sumption deals with the Samco principle. And letter H says, it is generally a necessary condition for the recovery of a loss that it would not have been suffered but for the breach of duty. But it is not always a sufficient condition. The reason, as Lord Asquith pointed out, and of course Lord Asquith pointed it out in the Stapley case, is that the law is concerned with assigning responsibility for the consequences of the breach. That's what the law is dealing with when determining scope of duty. And if one goes on, at paragraph 21, we can see it put in a different way by Lord Justice Denning in Roe against the Minister of Health. Is the consequence fairly to be regarded as within the risk? Paragraph D. And thus it's a question, and always has been a question, of allocating risk. And in the Samco case itself, it is that which the Court of Appeal failed to do. We see that again, and I keep you, if I may, in the Hughes-Holland case for convenience only. If one turns to paragraph 26, page 63, we see that the Lord Sumption refers to the fact that the Court of Appeal distinguished between no transaction cases in which the transaction would not have proceeded but for the defendant's negligence, and successful transaction cases in which they would have proceeded but possibly on different terms. Court of Appeal held that once it was proved that the lender would not have made the particular loan but for the valuer's negligence, the valuer was liable for the entire loss flowing from the transaction, so far as was foreseeable. And that, as we know, Lord Hoffman considered was the wrong place to begin. And so we know that in the Court of Appeal in Samco, they failed to take the step of allocating responsibility for the consequences of the acts and omissions of the defendant. And we know that in Samco, Lord Hoffman said that was the wrong approach. It was a flawed approach. And we see that if one turns to paragraph 35 in Hughes Holland at page 66, letter F, this is why in Samco itself, Lord Hoffman rejected the distinction made by the Court of Appeal between no transaction and successful transaction cases. It's irrelevant to the scope of the duty of care. So one is obliged to allocate risk. The Court of Appeal in Samco didn't allocate risk, but simply said, well, but for the negligent information, the transaction would not have been entered into. Therefore, D is liable for all the consequences of that transaction. That's the wrong approach, said the House of Lords in Samco. Yet that is precisely what we submit Mrs. Justice Yip did in this particular case. I turn, and I'm sorry, I'm looking only at the core bundle, but I'm turning to her judgment, and it is in the core bundle, at least at page 120, paragraph 53 of her judgment. At paragraph 53, she starts her analysis as a matter of looking at but-for causation. It's the first element that she discusses. In effect, she asks whether the information provided by the defendant caused the mother to enter into the transaction. And the transaction in this case is the decision to continue with the pregnancy. Because she says the answer is yes, the information provided by the defendant did cause her to enter into the transaction, brackets, to continue to have the baby, she comes to the conclusion that the defendant is liable for all the consequences of that, subject to the causation filters. And that is paragraph 58 of her judgment. Once it is established that, had the mother been properly advised, she would not have wanted to continue with her pregnancy, should it matter why she would have wanted a termination? Why logically should there be a distinction? In each case, the effect of the doctor's negligence was to remove the opportunity to terminate a pregnancy, which she would not have wanted to continue. She has done, in our respectful submission on analysis, that which the Court of Appeal did in Samco and which was determined to be wrong. And there is no analysis in her judgment from paragraph 61 really through to 63. There is no analysis of the risks that should be allocated to the defendant and the risks that should be allocated to the claimant, or the consequences of those risks. She doesn't do so at all. And we submit that that was an incorrect way of looking at the case. And we submit that it is effectively what Mr. Havers, both in his written case and in his oral submissions, is submitting to this court. Namely, because the defendant's information caused the claimant to continue with the pregnancy, the defendant should be liable for all of the consequences of the pregnancy. And that is simply the wrong test. We submit that perhaps the best way of dealing with it is to go back to Hughes Holland, go back to paragraph 1 of Lord Sumption's judgment, which will be on page 54, I think, of the bond. And he says, the issue in this appeal is, in summary, what damages are recoverable in a case where, 1, but for the negligence of a professional advisor, his client would not have embarked on some course of action, but 2, part or all of the loss which he suffered by doing so arose from the risks which it was no part of the advisor's duty to protect his client against. Transpose the language of a commercial transaction to that of a doctor-patient relationship, and the question becomes, but for the negligence of the doctor, the mother would not have continued her pregnancy. But the economic costs of the autism, which she suffered by continuing the pregnancy, arose from risks which it was no part of the doctor's duty to protect his patient against. Why do we say it was no part of the doctor's duty to protect his patient against? Well, simply because, as this court knows, the only feature that she was being asked to advise about was haemophilia. And she was not being asked to advise about any of the other risks associated with the pregnancy. Indeed, she couldn't advise about any of the other risks, and it would have been inappropriate of her to have so advised. And as has already been pointed out, when the pregnancy took place some years later, the mother will have known, and cannot be said not to have known, that there were other risks associated with the pregnancy, both to her and to the child. But the only risk that the defendant was taking responsibility for was the haemophilia. And we say that if one looks at the findings of Mrs. Justice Yip in relation to responsibility, such as they were, it follows the appeal must fail. If one goes back to the core bundle at paragraph 57, page 121, Mrs. Justice Yip's judgment, she says, I accept that a key part of the rationale in Chester was that the misfortune which befell the claimant was the very misfortune which was the focus of the surgeon's duty to warn. By contrast, the misfortune which was the focus of the duty here was haemophilia, not autism. And again, at paragraph 63, second line, it is true that the defendants did not assume any particular responsibility in relation to autism, but neither did the doctor in Parkinson, she goes on to say. So, looked at in the terms of Lord Sumption's question, paragraph 1 of Hughes Holland, and looked at in terms of an allocation of responsibility, which we submit is necessary to carry out, then it is clear from what Mrs. Justice Yip found that the doctor was only accepting responsibility in relation to the haemophilia, and that there was no reason to impose upon the doctor any further degree of responsibility. And my lord, my ladies, I could stop there, because that is the application we submit of the Samco principle. But I go on, if I may, briefly, to deal with the arguments put forward by Mr. Havers as to why that submission is wrong. First, he relies heavily upon the Parkinson and Groom case. As I submitted at the outset, Parkinson and Groom were not considering this issue. They laid down no principle in relation to Samco, but they were well aware of Samco, well aware that it was to be applied in such cases, and did so. And my lord, my lords, my lady, I know that you appreciate my next point, which is simply that if one looks at the facts of Parkinson and Groom, in each case, it was legitimate to say that the doctor bore responsibility not for a particular disability that occurs, but for all of the costs of having a child, because it was clear in both cases to the doctor that the woman did not want any child, not simply that she did not want a child with a specific disability. It follows that in both cases, it's rightly decided that the doctor is liable for all of the economic consequences, but in both cases, it is that they are correctly decided because the Samco principle leads one to that conclusion. In effect, the doctor was accepting the responsibility for all of the consequences. Really, the only matter that the Court of Appeal in those cases were grappling with was whether in the case of a baby who was born with a disability, damages were recoverable, given the decision that there had been by the House of Lords that damages when a healthy baby was born were not recoverable, and they were distinguishing that case. My lords, my lady, we submit that Parkinson and Groom takes the claimant nowhere in the context of this case. They weren't deciding the issue. They knew that Samco applied, and they appreciated that in the circumstances of those particular cases, the doctor bore responsibility for the economic costs of the disabled child. The claimant suggests that the defendant is effectively trying to draw a distinction between wrongful conception cases and wrongful birth cases, but that is wrong. The defendant makes no distinction as a matter of principle. Samco applies to them both. True it is that in some circumstances, the facts lead the court to determine that the defendant doctor is responsible for all of the economic costs of all the disabilities that the child may have, and in other cases, that the doctor is only responsible for some part of the disability that results. But that is because, in our submission, the facts in each particular case are dependent upon the allocation of risk. And the allocation of risk is what is of significance. So, my lords, my lady, Samco is to be applied. Samco is applied, and Groom and Parkinson doesn't suggest that it should not be applied. Mr. Havers goes on to say, but actually, in Parkinson and Groom, there was a decision by the Court of Appeal that, as a matter of principle, the loss sustained, all the losses sustained from the continuation of the pregnancy are to be borne by a defendant. That is the principle that was decided in Parkinson and Groom. But that's not right. That is not the issue that they were determining. They were not suggesting that one does not allocate risk. One simply categorizes the damage that has been sustained by the mother and says the defendant will be deemed to be responsible for that. The Court of Appeal, as I've said several times, were not addressing that issue at all. And the factual circumstances in both of those cases simply led to that particular outcome. So Mr. Havers moves on to suggest that in some way, even if one applies SAMCO, then it leads to the result that the defendant doctor is responsible for both the ASD and the haemophilia. And he says that is because if this is to be regarded as an information case, then the information provided by the doctor was sufficient to cause the claimant to continue with the pregnancy, and that will do. Well, with respect, that is doing no more than confusing the fact that the information simply caused the claimant to continue with the pregnancy. It does not mean that the information meant that the allocation of risk changed in any particular way. And Mr. Havers didn't deal with the allocation of risk at all. It is said that the kind of loss that Lord Hoffman was referring to in the SAMCO case is a sort of categorization of loss. Namely, is it economic loss? Is it loss arising from a personal injury action? Is it loss arising from a clinical negligence action? But an analysis of what Lord Hoffman was saying in SAMCO reveals that he was not categorizing loss at all. What he was saying was that kind of loss is the kind of loss for which a defendant is going to be responsible, is going to be the loss that is the consequence of his wrongdoing. And the consequence of his wrongdoing has to be determined by reference to the scope of his duty and the scope of his liability. And that is evident from the way in which Lord Hoffman was dealing with that expression, kind of loss. So, my lords, my lady, we submit that Parkinson and Groom take matters no further at all. That when one turns to the question of information, one cannot say that there is a different rule to be applied in clinical negligence cases or in wrongful birth or wrongful conception cases. And that it is apparent on the judgment of Mrs. Justice Yip and the reality of the situation here, that on an allocation of risk, the doctor was responsible for haemophilia and no more. On an information case, one simply asks the question, and this is an information case, what would the position have been in if the doctor's information had been correct? Answer, the claimant would have continued with the pregnancy. There would have been no haemophilia, but there would have been an autistic spectrum disorder. Mr. Havers appears to seek to get over that difficulty by saying that the pregnancy is indivisible, I'm not sure, with respect, I understand what that means, because a pregnancy is divisible in the sense of an allocation of risks relating to it. The defendant clearly took responsibility for haemophilia, but we know nothing, and the doctor knows nothing, of the circumstances that took place when the claimant became pregnant. Was she, for example, obese? Did she have hypertension? Was she somebody who was going to be advised that there were a number of risks in relation to that pregnancy? Maybe there were risks relating to the child. She will have known of all of those because she would have been given the advice during the course of the pregnancy and at the onset of the pregnancy as to what those risks were. And she would make her decision as to whether she was going to terminate or not in the light of those risks. The defendant had no input with that at all. And therefore, for Mr. Havers to characterize this, as in his written case he did, as an imbalance of power or an imbalance of information is simply not correct. There's always going to be an imbalance of information where one person seeks information from another. That's the case in all circumstances, transactional or otherwise. But there's no suggestion in Samco or in Parkinson or in any of the other cases that that's an analysis that the court should take, i.e., to determine whether there's some sort of imbalance of power. And if there is an imbalance of power, not to apply Samco. In any event, there is no imbalance here in the sense that the claimant was seeking information in relation to haemophilia. She received that information. The other risks she was not seeking information about, she was not seeking advice about, and the doctor was in no position to give any of that advice or information, and was thus in no position to accept the risks relating to it. So, my lords, my lady, we submit that on the two overarching principles submitted by Mr. Havers, Parkinson and Groom means that there is a different, means that the decision has already been taken, that the defendant should be deemed to have assumed responsibility for these consequences is wrong. And we submit that on a straightforward application of the Samco test, this is an information case, and in those circumstances, the counterfactual situation is that the defendant is responsible for the haemophilia, but not for the ASD. We submit that this cannot in any sense be regarded as an advice case in the sense that the defendant took on board all of the risks of the claimant proceeding with the pregnancy for the obvious reason that he knew none of them and had not been asked to deal with any of them and could not deal with any of them. And so, my lords, my lady, we come to Mr. Havers's final point, which appears to be that there should be an exception to the Samco principle in cases of clinical negligence, or as he put it, clinical negligence, particularly wrongful birth, wrongful conception cases. My lords, my lady, first, it is unclear whether Mr. Havers is suggesting that this should be an exception that relates to clinical negligence generally, or whether it should relate only to wrongful birth and wrongful conception cases. And it is therefore unclear what his submission is as to the extent of the exception or when it should apply. But in putting forward this so-called exception, what Mr. Havers is in fact doing is exactly that which he complained about in his case, and that is introducing into the law a degree of incoherence and unpredictability, simply consequent upon the fact that the actual outcome in this case is one that he doesn't like. The Samco principle, like it or not, is a principle that is both certain, it gives rise to predictability, it enables the courts to come to a conclusion as to how damages should be given and what the apportionment should be. Mr. Havis's exception is unclear because we don't know its extent. We don't know in what circumstances it should apply. Should it apply in all wrongful birth cases or only wrongful birth cases where there is this so-called imbalance of power? And thirdly, it is actually on analysis and an exception to an exception, because as was made clear, prima facie, when you enter into a transaction and suffer losses as a consequence of the defendant's breach, you're going to be responsible for all of those losses. But if it can be shown that you did not actually accept responsibility for some of them, then that is the exception. You're not going to be responsible for all. Mr. Havis then produces an exception to the exception, namely, that is the position except in wrongful birth cases or wrongful conception cases. And so there is no reason in principle whilst this exception should be applied, and it introduces uncertainty and a lack of clarity into the law, and most particularly, it's not a principled exception. In other words, it's only affected because the result that Samco achieves is not one that he, Mr. Havis, would wish to accept. My lords, my lady, Lord Legate. I'm sorry, Lord Legate and Lord Hodge.
Oh, okay. Well, I'll mind. To try to give a bit more justice to Mr. Haver's exception, I understood it to be limited to cases where personal injury has occurred, albeit not to the person who's the claimant. I mean, Samco does not apply in personal injury cases, does it? So in most medical negligence cases where a claimant has suffered personal injury, there's no question of ruling out some of the injuries because they're outside the scope of the duty.
Well,
and
my lord,
say that that you should treat this more as a personal injury case than as just an economic loss case.
well, my lord, there are 2 points perhaps. The first is one then has to enter into the debate as to whether it's an economic loss case or not, which I don't propose to do for the purposes of this argument, but one would have to do that. Secondly, but more fundamentally, though in the broad run of personal injury cases, the responsibility that is allocated to the defendant is straightforward, one can conceive of a number of clinical negligence cases where actually one does have to consider the risks that are borne by the claimant and the risks that are borne by the defendant. Let me give one example. A consent case. I go to the doctor. I say to the doctor, I wish to have an elective procedure. The doctor says to me, here are a list of the risks. One of those risks is pulmonary embolism. He fails to mention that there is also the risk of death. I say, had I known of the risk of death, I would not have had the operation. Actually, I don't die, but I do get a pulmonary embolism. There is a situation where I have in fact taken the risk of the pulmonary embolism, and therefore the doctor should not be liable for the fact of it simply because I would not have had that operation had I known of the risk that he should have mentioned but didn't. So there are circumstances in which it will apply in clinical negligence cases beyond the wrongful birth cases. And our submission is simply that where there is a case where you need to allocate risk, where the allocation of risk is not obvious, one does it using the Samco principle in all cases. Lord Hodge.
I just wanted to take you up on this idea that it was an exception to an exception. I mean, are you right to treat Samco as an exception at all? The reason I ask this, you started with a helpful 5 points, and you pointed out that scope of duty occurred before certain other questions were asked. And then you referred us later to a formulation, but for the negligence of the doctor, the mother wouldn't have continued the pregnancy, but the risk was something which was no part of his duty. That, I think, was lifted from or adapted from Lord Sumption in paragraph 1 of Hughes Holland.
Yes.
But I mean, if you're right about the 5 stages, then when Lord Sumption refers in paragraph 1 of Hughes Holland to but for the negligence of the doctor, he's really saying, but for the mistake of the doctor, that she wouldn't have embarked on some course of action. And part of the loss which was suffered arose from something that was not negligent, in a sense. You get my point?
I do. I do.
I'm not sure it's an exception at all. It's a prior question.
Well, it has been in some circles regarded as producing an exception in the sense that I indicated. In the run of cases, your starting point would be, well, you've entered into the transaction, and this is the whole point about whether one distinguishes between an advice and an information case. If it's an advice case, you've entered into the transaction. You've sustained losses as a consequence of that transaction. You are liable for, the defendant is liable for all of the losses. However, what Samco is saying is one actually then has to look at the allocation of risk. And if one looks at the allocation of risk in that way, then the allocation of risk, which means that the claimant retains some of the risk, produces an exception to the prima facie position. Now, it depends whether, and perhaps I don't want to get into this debate, but I can. It depends whether one is really looking at Samco as a causational principle or is a scope of duty, scope of liability principle. I submit that it's a scope of duty, scope of liability principle. It's not a causational principle. It's got nothing to do with causation. If that's right, then yes, it's not an exception to an exception.
Yes, that was my understanding, that in your presentation of 5 points, that it wasn't an exception to an exception.
Absolutely.
It's only if you go further and take the view that it's a causation principle that
Absolutely.
that you get into that sphere.
Yes.
Thank you.
Lord, I think Lord Sales was first, Lord Burrows.
I mean, it was really to call attention to part of the reasoning in Hughes Holland, which I think rather supports what my Lord Hodge was saying about whether this is an exception to an exception or actually the starting point. It's just to mention that in paragraph 27, Lord Sumption refers back to the important passage in Samco by Lord Hoffman at page 211, where he says it's the wrong place to begin looking at what is the loss that has flowed from the breach of the duty. You should start with the duty itself and then see what loss falls within the scope of the duty. So it's really just to support what my Lord was saying, and indeed, as I understand it, what you're saying.
Yes, and my Lord, to make it clear, I only introduce it as an exception to an exception if one, as some have chosen to do, regards Samco as a causational principle. I do not submit that it is. I submit that it's not a causational principle. Lord Burrows, I'm sorry.
Thank you. I'm just jumping in while there seem to be a number of other hands up to get my questions in. First of all, I just wanted to ask, as I understand it, Mr. Havers submitted that had this been a wrongful conception case or seen that way, you are conceding, or you have conceded, that this claim would be successful. I think he made that submission twice. Is that correct?
No. What is correct is that as a factual analysis, most, wrongful conception cases will turn out to be advice cases, because in most cases, the defendant doctor knows that what the woman is trying to do is to avoid having any children. Thus, in a sterilisation, you know, or can be taken to know, that the woman does not want to have any children at all. And therefore, in those circumstances, as a matter of factual analysis, it is easy for the court to conclude that the defendant doctor will be responsible for all of the consequences of the woman having the child. But we do not concede that as a matter of principle, one simply says, oh, in wrongful conception cases, it should always be regarded as an advice case, or that the allocation of risk is always on the doctor.
Thank you for that. And then a separate point, really. We've been asking ourselves how far personal injury cases, generally speaking, might fall within SAMCO. And I've just been concerned about this almost from the start of this case, because am I wrong in thinking that the vast bulk of negligence cases, including in this sense, have nothing to do with SAMCO, because SAMCO is only concerned with advice or information, that is statements or failures to state, and nothing at all to do with conduct, that is the negligent performance of an operation, the negligent driving of a car. You wouldn't start to ask, would you, about SAMCO in conduct cases? Isn't it confined to a subset of negligence concerned with statements or failures to state?
My lord, not entirely. You're right that if one went through my 5-point checklist, in most personal injury actions, number 2, analysing the scope of duty, is straightforward. In other words, on a road traffic case, one jumps pretty rapidly to number 3 and asks what the breach is. One doesn't need to analyse it. But that doesn't mean to say that as a matter of principle, it is wrong to determine the allocation of risk in personal injury cases, along with all other negligence cases. And to make a distinction simply because we are looking at advice or information on the one hand, or conduct in the other hand, is not justifiable. In other words, one still has to ask the question, what is it that what consequences will the defendant be responsible for? The fact that it's an easy question to answer in most personal injury questions, in most personal injury actions, is nothing to the point.
The reason I find difficulty with that answer, although I can understand where you're coming from, is that the whole point, as I understand it, of SAMCO is that you decide the relevant allocation of risk by a counterfactual. And the counterfactual given is only possible to apply, as I understand it, in relation to statements or failures to state. You can't apply the counterfactual, the SAMCO counterfactual, as I understand it, where it's a conduct case, can you?
Well, in my submission, you can, but let's take the two situations. First of all, personal injury actions can be related to advice and information that is provided, and I've given an example. So one would have to say that if there's going to be an exception, it should be limited to conduct. And if one is going to say it's limited to conduct, one has to look for the principled reason why that should be. Thus, if I, as a defendant, am looking for the consequences of some symptomology that a claimant has, and I, for example, should have carried out imaging in order to ascertain that the cause of the symptoms, and because I didn't do that, I failed to pick up a completely silent lesion that would otherwise have been picked up. The question can be asked, well, what is the allocation of responsibility? Now, if one is going to say that in that case, the allocation of responsibility should not be determined by SAMCO, then that is an exception. But one has to ask, well, what's the principled reason for coming to that conclusion? And my submission that there is no principled reason for coming to that conclusion. Lord Burrows did indicate that he was trying to ask his questions because others were trying to get in before him. I don't know if there are, there seem to be no further questions.
Sorry, I didn't mean that. I meant while other people were asking, I'd also ask my question after everybody else.
My lord, my lords, my lady, our submission is, as I indicated at the beginning, straightforward. One goes through the 5-point checklist. Number 2 in the checklist is to analyse the scope of duty, scope of responsibility. One does that. In personal injury actions, it is generally something that can be done pretty rapidly. That doesn't mean to say it should not be done in the appropriate case. If you are going to do that, you do it in accordance with SAMCO. Parkinson and Groom said nothing different. They weren't deciding that point. There have been no cases in which it is suggested that that should be different. And indeed, it would be odd if Lord Hoffman considered that personal injury cases should be different, that he would use his parable of the mountaineer as the example that he puts forward. And so in our respectful submission, there's no reason as a matter of principle why there should be an exception, and there is no precedent to suggest that there should be. Thus, applying SAMCO, we apply it by reference to paragraph 1 of Lord Sumption in Hughes Holland. We adapt the wording to the particular situation that we have. It produces an inevitable result on the basis of Mrs. Justice Yip's analysis of the case, and it produces the same result if one thinks for a moment of the circumstances in which the doctor was in and what the doctor was advising about. There is no justification for any exception to that principle, certainly as it applies to information and advice in the context of a clinical negligence case. We would say no justification in principle, even in terms of conduct in a clinical negligence case, though that is not this case for obvious reasons. My lords, my lady, I don't know whether I can assist further. I have, as Mr. Havers, I've not gone to the detail of the judgment in SAMCO because I'm well aware of the fact that you've been taken to the detail on innumerable occasions, which is why I restricted myself to analysing it via Hughes Holland. But those are my submissions.
Thank you very much indeed, Mr. Maskery. In that event, we can turn to Mr. Havers for his reply.
Thank you, my Lord. Lord, first, my own friend complains that neither I nor the judge dealt with allocating responsibility for risks as between the parties. My lords and my lady, as I understand it, that is done by virtue of the checks or the filters or the principles which we have been taught in SAMCO and in Hughes Holland to apply in economic loss cases. And nowhere in those cases will you find the court actually saying, this is how I propose to allocate the resources or the responsibility for the risks. On the contrary, the exercise is to consider and to apply the various filters which are set out in SAMCO with a view to seeing where the application of those filters takes one in terms of the division of responsibilities. And both I and the judge have sought faithfully to address each of those filters in the course of my submissions and the judge's judgment. Indeed, if one goes to the passage relied upon by Mr. Maskery, volume 2, page 60, at the foot of the page below H, it's not always a sufficient condition. The reason is that the law is concerned with assigning responsibility for the consequences of the breach he would include and for the risks involved, and a defendant is not necessarily responsible in law for everything that follows from his act, even if it's wrongful. A variety of legal concepts serves to limit the matters for which a wrongdoer is legally responsible. And it is those legal concepts which I have sought to address and the judge sought to address in her judgment. So I would respectfully reject that criticism. Secondly, my own friend seeks to rely upon paragraph 57 of the judgment of the judge in terms of the purpose of the duty that she there articulated, and says, well, QED, that's what the judge found the purpose was, the defendant wins. Can I invite you to go back to paragraph 57? It's in volume 3, page 82. Because he didn't read on, and picking it up in the second sentence, by contrast, the misfortune which was the focus of the duty here was haemophilia, not autism. However, the focus of the defendant's duty, or the purpose of the service, to put it another way, was to provide the claimant with the necessary information so as to allow her to terminate any pregnancy afflicted by haemophilia, as this pregnancy was. She repeats that purpose in the beginning of paragraph 62 in almost identical terms, and those were the terms in which Lady Justice Nicola Davis, as I've shown you, herself articulated the duty in this case. My Lord, next, my own friend suggested that there may have been other risks in this particular case, risks involved in becoming pregnant. He mentioned obesity and so on, about which we know nothing, but which she may have wished to and may have needed to take into account. But the point is, we submit, that those were all risks which she would have taken into account necessarily before she decided to become pregnant. The key point is that by the time that she would have found out that her child was had haemophilia, all those risks had been long since taken into account, so that the decision whether to terminate the pregnancy or not was, as we've submitted, truly a binary choice to be determined only by the question whether the child had haemophilia or not. So, my friend, cannot, we submit, rely upon paragraph 57 as he seeks to, given how the judge continued to identify and articulate the purpose of the duty in this case. My Lords, if this is only an information case and not an advice case, however difficult it may be to apply that distinction to a case as different as this case is from the commercial circumstances of Samco and Hughes Holland, if that's so, can I invite you to go back to page 269 of volume 2. No, I'm sorry, it's 268. I've already added the extra page. And the passage I showed you earlier where at E, Lord Hoffman sets out the distinction between information cases and advice cases, and at F, if his duty is only to supply information, he must take reasonable care to ensure that the information is correct, and if he is negligent, will be responsible for all the foreseeable consequences of the information being wrong. Now, I appreciate that one may need to be a little wary about stopping there, given the other factors that Lord Hoffman said should be taken into account. But if the information is incorrect, which it was in this case, because the claimant was a carrier of the gene, then at least according to that passage, the defendant will be responsible for all the foreseeable consequences of the information being wrong, and the defendant has admitted that those consequences included, those foreseeable consequences included that the child may have autism as well as haemophilia. Well, can I then turn to the question of conduct, which was raised by Lord Burrows? This is a conduct case. It's not just an information case, in the sense that it's not just a case where the doctor wrongly informed the claimant that she wasn't a carrier of the gene. It's very much a conduct case also, because what the doctor failed to do was to take the necessary steps to discover whether she was a carrier of the gene. In other words, to refer her to the hematologist for genetic testing. So that's why we said earlier that this case is a conduct case, and why that is an important distinction to be made from the commercial cases, Samco and Hughes Holland, where they were information cases only. Norton Lady, can I just check that that's all I wanted to say in reply? Yes, one last point. The learned friend says that it's never been conceded that if this was a wrongful conception case, that the claimant would recover in full. I have to say that's never been our understanding of the defendant's position. I was looking for a reference in the judge's judgment, which I believe to be there, which is to the opposite effect and confirms that that had been conceded. I've got a reference in my notes to paragraph 28. Now, I'm so sorry. It's paragraph 64 of the respondent's skeleton argument in the Court of Appeal. The reference is volume 1, page 184. I'm not sure how much at the end of the day is going to turn on this, but your lordships may in due course wish to turn up that paragraph in order to see that certainly in the Court of Appeal that appeared to be the respondent's position. Finally, I spent a little time in my opening stressing to the court that this is a wrongful birth, that Groom and Selby was a wrongful birth case like the present, and making submissions as to why it doesn't matter what was the reason behind the mother in Groom and Selby and the present mother not wanting this particular pregnancy to continue. That, in my submission, is the answer to Mr. Maskery's point as to the distinction to be drawn between those cases and the present case. The Groom and Selby was a wrongful birth case. The wrongful conduct was partly conduct in failing to test the claimant for pregnancy, partly information, failing to tell her that she was pregnant. But the wrongful conduct was in failing to give her the opportunity to terminate that pregnancy, and that's exactly what was the wrongful conduct in the present case. And Lords and my lady, unless I can assist you further, those are my submissions in reply.
Thank you very much indeed. We're grateful to both counsel, not only for the clarity of submissions, but also for dealing with the matter so succinctly. We're going to be considering this case alongside the case of Manchester Building Society, which we heard a few weeks ago, which is a more root and branch duration of Samco. And we'll issue our judgments in both cases just as soon as we're able to. Thank you both very much. The court will now adjourn.